Okay, so guys, on this particular video, you are going to be hearing directly from Nnamdi Kanu'S lawyer, Aloy Ejimako. He went on airspace to explain what really happened that day in court, and what prompted Nnamdi Kanu to say that he is going to defend himself. He told his lawyer to step back while he speaks for himself. So many people have been saying all sorts of things online that Nnamdi Kanu disrespected his lawyer, that it seems like Nnamdi Kanu'S lawyer is no longer doing what he wants him to do. Maybe they have issue or something like that. Nnamdi Kanu'S lawyer is no longer qualified for the job. No, the narrative is different from what really happened. Now, Aloy Ejimako, in this voice note that you are going to listen to, explained why Nnamdi Kanu did that and what next. Yes, he now, in this voice note, he spoke what next is going to happen in this Nnamdi Kanu's case. Just listen.
So there was no way we could thump our nose at the court, even though we had the full assurances and confidence that the summons was flawed at law. The same judge who was recused, had no authority to summon us. So we went to court yesterday to tell the judge exactly that, and also to ensure that we are present to protect the constitutional rights of Mazi Nnamdi Kanu. If we were not present, our absence could be injurious to his constitutional and legal rights. So we had to be there to make that point that to the judge that, hey, listen, you don't have this one anymore. You don't have any business with this case anymore. And that's it. But that it didn't seem to be sinking in, and I believe I have to bring you up to speed how it started, because how the cookie crumbled. It was the prosecutor, the private prosecutor for the federal government, who began to speak first, informing the judge that the prosecution is ready for trial. Are you listening? Are you hearing me?
Yes, we're hearing you, sir. We're hearing you.
Okay. So that's when I got up. And raised an objection on the record that the court had to inform us first why we were there. So the court began to inform us with a lot of aplomb and authority, purporting to be to still possess jurisdiction. I opposed that vehemently, and it went on back and forth between me and the prosecutor on one hand, and between me and the court on the other. And Chidi, as you know, in every common law system, even where you live in Canada, a defendant has the right, or let me say the privilege, to address the court if the court so permits. So those people who want to say that Mazi Nnamdi Kanu was rascally, those people, they are not. I don't know whether it's a product of propaganda, but he just didn't get up and disrespected the court and started speaking. He was permitted to speak from the dock. That is how lawyers put it. He asked for permission to speak, and he has the right to speak. Well, you can say a privilege. In some situations, it could be a right. But in this situation, let us just assume it's a privilege. So the judge extended that privilege of speaking for himself to him. And the way he spoke is the way every defendant presumably would speak. They speak from the heart. No, you would not expect him to speak like a lawyer who is robed and with his wig and gown and everything. We have some boundaries of privilege when we speak in court. There are lines we can't cross ethically and professionally. But a defendant is permitted to speak from the heart. That is the purpose of it. You speak from the heart, you tell it the way it is. So that's exactly what he did. But some people may have mixed feelings about it. But, he let the cat out of the bag, and that's it. And you can say that his lawyers were the carrot, he was the stick. So be that as it may, the purpose was achieved. And the purpose was that ultimately we did not submit or succumb to the authority of the court to recalendar the case and try it, having been recused pursuant to an extant court order. So whatever the court did at the end is a nullity. The court purportedly adjourned sine die, meaning indefinitely. If you don't have authority to hear a case, you have no authority to enter any subsidiary order, such as adjournment sine die. So we have a whole lot of options we can pursue. rising from yesterday, but I rather keep that very close to my chest. I don't want our legal strategies going forward to be for public consumption. Thank you.
Thank you very much, sir. That's really why we wanted to have you here. Now, a lot of the things that you'll be saying here will be easier for people in the wig and gown of your profession to understand. But to lay people like me, there are some questions that I'm going to ask you, which will represent a lot of what has been flying, up and down online. One of them is this. Even though you've talked about it, but I want to ask you a straight question. You have asked that the judge recuse herself from this matter, and you have said that the judge does not have jurisdiction over this matter anymore. My question is, why did you still go to court knowing that this person sitting there is someone whom you have already said does not have jurisdiction over the...
Okay. Let me just take this question very quickly. I mean, anybody listening here is living in one country or the other. Every nation is organized under a set of laws and a constitution, and law and order must be in play. I mean, there's no country in the world where you live and at the same time you disregard the rules and laws and processes of that country. We have no authority within the confines of the territorial boundaries of Nigeria to thump our nose at the judiciary and say we're not going to court. Who are we? Come on. People need to get reasonable. Nnamdi Kanu'S is in detention and people expect him to say, I won't go to court. He could possibly be taken to court forcibly, and it will be very embarrassing. And if we as lawyers say we won't go to court, it might even be tantamount to professional malpractice. That we failed to go to court. We went to court on a limited appearance. I announced it in open court that we are here on a limited appearance and we are appearing under protest. It is done, even in Canada where you live, Chidi, and everywhere in the world. It don't say you won't go to court. Even police summons, common police summons, you must answer. You go there and protest your innocence, but you won't say, I won't go to court, I won't go to police station because you believe that they have no authority to summon you. You just can't do that in any country. I don't know why, in the case of Nnamdi Kanu, some people expect different or expect the lawyers to act differently. As if the lawyers are something gods. We don't have the coercive powers of the Federal Republic of Nigeria. I wish we do. In that case, we shall now, marshal or purvey those coercive powers to prevent some injustice from being done. But we live under the authority of the state, pure and simple. It's a hard truth. Very inconvenient truth, but it is the truth. So if the court says you must come, you go. You don't stay in your house and decide that the court doesn't have jurisdiction, because the court can proceed in absentia. It can proceed with the proceedings in your absence and enter some orders or rulings that will be permanently injurious to your legal interests. And then how do you defend that? Reasonable men and women, even non-lawyers alike, will be asking you, but what authority do you have to refuse to honor a court order? It's a court that summons a man, he goes to court and proves his innocence, and he's sent home and he's set free. So you don't stay in your house, or especially for someone who is, within the confines of a security agency detention facility, and you say, I won't go to court. Something got to give. So I don't know why this is hard for people to understand. But Chidi, quite frankly, I think a lot of people understand it, but it's a mischief. There's a certain mischief that is coming from people that are fronting to be Igbos or to be our people. I don't know whether they are fake or real, but they engage in this continuous mischief or finding fault every time in somebody and trying to lay blames that shouldn't be laid, and so on and so forth. And from there they now begin to engage in whole-scale acts of blackmail on the social media. But the legal team is not perturbed. We have a job to do, and that's what we are concentrating on.
All right, thank you very much, sir. The next question is this: When you requested for the judge to recluse herself, I've heard in some quarters that request was not granted, and that was why the judge was back in court. So could you speak to that? What happened after you requested
Yes.
for her to recluse herself from the matter?
Okay. Well, okay. After this segment, I will ask everybody to go to my Twitter handle. I'm going. It's a very good question. I'm going. I didn't know that there is that lacuna there. I didn't know that people didn't have a full understanding of what transpired on 24th September last year. The request for recusal was made, and the judge very willingly and freely consented to the recusal, and she proceeded to enter and enroll an order thereof. That order is subsisting and valid, and I have a copy of the certified version of it. I have it electronically, so I'm going to scroll and get the order, screenshot it, and post it on my Twitter handle. Because I noticed that people are probably not aware, they have not seen the order itself. So the recusal was a completed judicial event. Nothing was left, and that wasn't the issue yesterday. The judge had no misgivings about whether there was a recusal order or not. Rather, she was telling us that the chief judge issued a memo, some kind of a directive to her to continue with the case. So my argument, which is sound in law, is that the directive of the chief judge of the Federal High Court or a memo cannot override a court order. Even lay people know that a court order is different from a directive or a memo, even when the memo or directive issued from another judge. An order is an edict, is a decree by a court, and it has higher tenacity than a mere directive or a memo. So he might be the chief judge of the Federal High Court, but he's still a Federal High Court judge with a coordinate judicial rank with the Justice Binta in Nyako. So they are equals before the eyes of the law, and under the Constitution they possess equal jurisdiction and authority. The chief judge is merely a primo inter pares, first among equals. So he cannot, by a directive or a memo, override a subsisting valid court order that has not been set aside. So that's the presentation I made in court yesterday to push back at this thing that I saw as a burgeoning unconstitutionality. So there was no doubt about a court order. The only issue was the memo. And we were not going to succumb to the contents of a memo that we didn't even see. Even if we saw the memo, our position would have been as rock solid as it was when we didn't see the memo. So that's it. That's
All right.
it.
So guys, I believe with this voice note, you've been able to understand what really transpired in court that day. What Nnamdi Kanu did, it does not mean that he is not happy with his lawyer or he disrespected his lawyer in any way. He just did it because he needed to portray a point, and he has done that. So Aloy Ejimakor is still working with Nnamdi Kanu, and he is still going to work with him until he comes out of the